Good morning, everybody. Thank you all for joining us. We're going to wait till the rest of the folks in the waiting room get in here to join us. All right, Diana, if you don't mind just letting in any additional folks that pop into the waiting room, that would be great. I'm going to go ahead and get us started. Excuse me. I'm going to start us off like I do each week with just some very brief Zoom housekeeping tips. So we do ask that everybody stays muted during the Zoom unless you want to unmute yourself to ask a question. It just makes it easier to cut down on background noise and for everybody to hear. So if you're not sure yet where your Zoom housekeeping bar is, welcome to 2026. We've been using Zoom for 6 years now, which is so crazy. I one of my Facebook memories popped up recently, and it was an invitation to a bunch of my friends to get on Zoom for a get together because of the stay home orders that had been issued. And people were like, "What's Zoom and how do we use it?" And this is so confusing. And I was among them. So it's just wild to think we've been using this for 6 years. But, anyways, I digress. Your toolbar is at the bottom of your screen. That's where you will find your audio and video buttons. So you can mute yourself during the Zoom, but unmute to ask a question if you would like to. And you are welcome to be on camera or off camera, whatever works best for you. We also, the chat might be flashing. The chat button might be flashing. I did put a message into the chat letting you know that if you have questions for next week's Q&A or any future Q&A, you can send them by email to info@condolaw.net. We do ask that you get those questions to us no later than 4 p.m. on Monday afternoon so that we have the day on Tuesday to prep our answers. And if you miss a Q&A and you're curious to hear about what we talked about or just want to kind of catch up on some of the latest goings on that we talk about here, the link in the chat will take you to our YouTube channel where you can look at all of our past Zooms up to a certain point. We archive the ones that are older and less relevant. And you can also do a search, not on YouTube generally, but in our specific YouTube channel. So if you have a particular topic that we might mention in the chat today, for example, saying like, well, we've done a lot of Zooms on this recently, go look at our video channel and watch those videos because we're not going to repeat, that topic again today. You can do a topic specific search in our YouTube channel. And especially if the topic is a little bit less common, that search function is very useful. If you put in a term like assessments or something that's very, very common, then the search becomes a little bit less useful because you'll get a lot of results in return for that. Moving on in our housekeeping items, I want to remind you that we are here to talk generally about legal and other information that is helpful to community associations in Washington State and all the folks that work with and live in them. And we're not here to give legal advice. So please keep that in mind when you send us your questions, and keep that in mind in case somebody were to do something like send you a link to one of the videos and say, you have to do XYZ because of something that I heard on the condo law Q&A. What we're doing here is not giving legal advice. We're just talking generally about things that are applicable to a lot of community associations in Washington. So if that happens and you're in a scenario where you need legal advice, you need to get that legal advice from your association attorney, not from our Q&A. And by the same token, sometimes we get lots of very specific questions where people are giving us excerpts from their governing documents or several paragraphs of facts and background leading up to a particular question. We can't answer questions like that. We do also get a fair number of questions where it's really clear from how the question is written that someone is angling for a specific answer. And we also tend to forego answering those as well, because our role here is just as generally informative people and not getting ourselves involved in particular situations that folks are dealing with. So I already did my plug last week for making sure you hire an attorney when you don't need one. So I won't do that this week. But if you want to hear about my soapbox, you can go back to oh, wait, never mind. Sorry. That's another thing I should announce. We don't have a video for last week because Zoom changed its interface and we flubbed up in the beginning of the meeting and neglected to record last week's Q&A. So I apologize for anybody that was, waiting with bated breath for the YouTube channel to refresh and include that link, but we will not have a video link for last week's Q&A on the YouTube channel. We are going to have time for extra questions today. So if you have any questions that you would like us to cover today, please feel free to pop them in the chat. Just keep in mind sort of the general parameters that I just mentioned. We are also reminding everybody that the WSCAI annual conference is coming up April 9th, 10th, and 11th. So we are like 2.5 weeks away. It is the week following Easter for those that track that particular holiday. And if you have questions about that event, don't know what I'm talking about, or would like to register, you can go to wscai.org to find more information about the annual conference. And if you do come, please come say hi to us at the booth because we will be there. And then briefly, before we jump into the questions, we wanted to cover a couple of legislative updates. And actually, before we get to that point, I think I'm going to start with something different, which is we were talking in our prep meeting today about how many clients are choosing to restate their governing documents in advance of or in preparation for, or maybe right around the same time that Kiowa for All takes effect. And we were also chatting about an article that Hillary Bublitz, who is the chair of our Legislative Action Committee, wrote in the WSCAI Journal, this particular edition, about sort of weighing the pros and cons of updating your governing documents. And there was one scenario that we talked about that I think is worth sort of shouting out here for everybody to consider, which is when Kiowa for All takes effect in 2028, the statute sets the minimum threshold percentage to amend recorded documents like the Declaration at 67% of the voting power in the community. And there are some communities in Washington state, such as maybe Old Act condominiums with a 60% voting threshold, or we have one very large HOA client that is allowed to amend their governing documents provided they get, I think, either a majority or 60% of the people present at a meeting to vote on an amendment, which is a much lower number of owners voting for that amendment than it would be if you had to count the percentage of the total voting power in the community versus the percentage of those voting at the meeting. If you are in one such community where your documents currently allow you to amend your declaration with something less than 67% of the total voting power in your community, and if you have discretionary things that you want to change, or if a restatement project has been on your radar for a little while and you've been trying to figure out the timing for it, you might want to consider accelerating that project so that your voting is complete before January 1, 2028. Because once January 1, 2028 hits, the statutory voting threshold will override whatever is in your governing documents. So if your documents currently allow you to amend with a vote of 60% of the voting power, come January 1, 2028, when Kiowa for All applies to everybody, that will invalidate the 60% threshold that's in your documents and require you to get 67% of the voting power in your community to amend your declaration. So keep that in mind if a restatement or amendment project has been, kind of percolating, but maybe put on the back burner. We do know a lot of communities that are restating now, but we also know a large number of them that are kind of planning and budgeting in advance and thinking that 27 or 2028 or 2029 might be the time when they do that. And for communities with a higher voting threshold or a 67% voting threshold now, the timing is less of an issue. But if you have a lower voting threshold, you should consider doing it sooner. So that would be a question for you to bring up to your association attorney if you're not sure what your required percentage is to amend your declaration, and to talk to them about the timing of an amendment or a restatement if that's something you've been considering. Jennifer, did you want to add anything to that before I jump us into the questions?
I don't think so.
Okay. All right. Here's our first question. Is it required to have an attorney review rules and regulations if the association decides to rewrite them themselves? So as you might imagine, the very short answer to this is that it is not required, but it is strongly recommended. Having a community association attorney review the rules before you publish them to your ownership ensures that they are enforceable, and also ensures that you can shift liability for certain things if there is a mistake made in the implementation of those rules. And just as a short and non-complete list of things that we have seen in the last year or two put into rules which are not enforceable because the rules are not where these things go. Some examples of recent rules problems include things like putting an insurance shifting provision in the rules when there isn't a corresponding provision in your declaration, putting a rental restriction in your rules when you don't have one in your declaration, shifting responsibility for windows and decks to your owners by rule instead of amending the declaration. We've seen clients implement rules that are only applicable to children, which calls into question discrimination concerns. We have seen rules that purport to assess fines immediately, which controverts the statutory requirement that you tell people ahead of time that they might be fined. That's the whole concept of due process, which is a statutory requirement. You can't get around that by rule. This was a little bit longer than a year ago, but I have had clients try to put it right in their rules that the board will never conduct a hearing on a compliance fine because the board just didn't want to. So these are just, I mean, we've seen a Wakaiowa community board adopting rules without the required notice and comment period for the owners. So under Wakaiowa, all other communities have the ability for the board to adopt a new set of rules or to change your existing rules and just vote on it at a board meeting, publish those rules to the owners. And as long as you've given a reasonable period of notice, those rules can become effective without a vote or comment of the owners. Wakaiowa requires the board to adopt proposed new rules, send them out to the owners, and allow a comment period by the owners before the board formally votes to adopt those rules and make them enforceable against the community. So we've seen communities do that wrong because they were doing it without the advice of an attorney. We've also seen rules that purport to strip delinquent homeowners of their voting rights or the use of common elements within the community. So none of these things can be done in your rules. And yet we see folks try to put all kinds of stuff into the rules that cannot be enforced unless they exist somewhere else. So that is the long answer and the explanation for the short answer, which is even though that it's not legally required that you have an attorney review your rules and regulations, we strongly recommend that you do it because of the number of problems and issues we've seen over the years when that hasn't been done. Jen, did you want to add anything to that?
Just briefly, some of this is also honestly shifting risk. So when boards do things on their own, such as amend rules, or honestly, we've had some boards try to amend their declaration by themselves, and the board gets it wrong. They make a mistake. The board is on the hook for that mistake. If the board had an attorney review the document, review what they were trying to do, some of that risk shifts so that if the attorney makes a mistake, the attorney is the person or the firm is on the hook for that mistake. So it's shifting risk, potentially shifting liability for mistakes, and the attorney should know what can and can't be done. I've had a board argue with me that the rules overrode the declaration. So, and Valerie's laughing because I'm sure she's run into that too. So, yeah, you know what's best for your community as a board. Running how things are done by an attorney just ensures that you can get what you want potentially, but maybe not in the way that you anticipated. And also shifting risk where it's easier borne. You don't want to be the board on the hook for a judgment or what have you because you made a mistake. So, Valerie, unless you have something else, I'm going to move into, okay, I'll move into the next question. So, are some declarations written that state the number of directors is limited to X, while others say at least? And if it says at least, does that mean more than X? Have you run into any interesting experiences with this? So, we, declarations and bylaws are written by an attorney for a developer, and some use a similar template, others don't. So we've seen some doozies out there. Some have been written with no maximum number. For very small communities, I know that we've written that every owner is on the board or at least can appoint someone to the board to represent their unit. So for communities under 10 units, that generally works pretty well, but it's up to the community. Um, okay, what did I just do? There we go. So it's very, it really depends on what's in the governing documents. You need to double check your declaration and bylaws. Sometimes they'll have different language. We've had communities where the declaration says a board of three, but the bylaws say at least one. So they were operating on one board member for a while and were shocked that no, the declaration controls there. So when you have an indeterminate number, say no less than three, no more than five, or no less than five, no more than seven, we've seen both. How it typically works in that particular situation is that at the annual meeting, the unit owners or lot owners, whomever, vote first how many board seats there are, and then elect people to those seats. Um, Typically, it's a board of three members, a majority of whom must be owners. But we don't believe that having no limit means every owner who wants to be on the board gets to. We still think that each board member would need to have a majority of the owners voting agree to have them on the board. So some related questions. If the documents say shall have a board of five, can it function with less than five? What if you can't fill all board positions? So the risk is much lower if you have enough board members, active board members, to reach quorum. So if you have a board of five and you have three active members and either can't fill two seats or the two owners in those seats aren't active, you still have a quorum. Statute says that a majority of quorum is the action of the board. So the risk is low if you can make quorum. And frankly, it also depends on what kinds of decisions are you making. If they are more controversial, there's more risk to the board that someone's going to challenge. But as long as you can meet quorum, you should be generally okay. So, another question, if there's a vacancy on the board, can the remaining board members decline to appoint a member who volunteers? Yeah. The power of appointment when there's a vacancy on the board makes that decision. Just because somebody volunteers doesn't mean that they are required to be on the board. Um, and the owners always have the option to call for a meeting to elect or to elect someone for a vacant board position. So just because someone volunteers doesn't mean that you are required to allow them to be on the board. For those who know Ken very well, he has a story about an association that I think for like 5 years had one individual who wanted to be on the board but could never get a majority of owners to approve him because he was so problematic. And then people just got tired of dealing with him, so he got elected to the board. Valerie, did you have anything that you wanted to add to that?
No, I think you covered it. Our next question is also related to this most recent legislative session. And the question is House Bill 1501. Please give us an example of how this bill would be used versus a regular association records request. Why did the legislature feel that this bill was necessary? I'm going to start with that second question first. One of the things that I've learned in serving on the Legislative Action Committee the last several years is how often legislation arises from a single anecdote that a legislator hears from one of their constituents. And as we all know, most people who are, reasonably happy with how their community association is handling things aren't calling their legislators to be like, hey, I live in this totally fine community and they do like a B plus job and I have no complaints about them, right? They're hearing from the people who have horror stories. And there is a perception in Olympia that boards are routinely ignoring owner requests for information or owner questions about governance issues. And that is where this bill came from. And as for how it would function differently than a regular records request, I think you look at the text of the bill itself. So, first of all, the bill only pertains to letters that are sent to the association by certified mail, where an owner has questions about topics related to association governance or operations. And when an owner submits a letter via certified mail to the association, that triggers a 30-day response deadline, during which time the board is required to either respond to the inquiry or notify the owner that they're going to need additional time to respond in very specific scenarios. So, for example, let's say your board meets on the last Thursday of every month and it's the last Friday of the month and you get a new letter that day, and the next board meeting would not allow you to respond within the 30-day window. You can respond to the owner and say, hey, look, we got your letter the day after the board meeting. I literally just sent an email to a client 2 days ago. No, yesterday, Tuesday, knowing that they had had their board meeting on Monday night and would likely not be able to vote on the thing that I was asking them to vote on until their April board meeting, right? So sometimes a timing issue like this happens. In that scenario, the board could respond to say that they need a little more time so that they can consider the request, answer the questions, make any decisions they need to make at that board meeting, and then respond. If they need more time because it's a particularly complex question or because they need professional review of the question, for example, they need to get an attorney opinion or an architect opinion or, kind of fill in the blank here, that is also something that is possible under the language of the bill. However, the bill does require in that case, well, sorry, and I'm going to move on to one other thing that the bill does that is different than the statutes as they exist now, which is that the board can adopt rules to limit each owner to one response every 30 days. And the reason that this came about, this was not in the original text of the bill, but most of you on this Q&A call have dealt with someone who sends a 17-page letter to the board demanding a myriad of different records and asking 28 different questions about 14 different topics. And the bill was written to specifically allow the board to narrow the scope of each response within a 30-day window. But if you only answer certain parts of the owner inquiry within the first 30-day time frame, then you have to save up the rest of those questions and respond to them in the next 30-day time frame. So just keep that in mind. The limitation on the number of questions or the number of responses per 30 days doesn't allow you to avoid answering those questions permanently. It just means you get a little bit more time to deal with multi-part complicated requests for information. In that scenario, though, the board would have to have adopted a rule limiting each owner to one response per 30-day time frame. So you can't do that by default under the statute. You have to adopt a rule. We have a lot of clients that they have what's called a communications policy. And the communications policy before this bill would just set forth, expectations for how owners are to communicate with the association, where to email inquiries, when to expect responses, how to get something added to the board meeting agenda for the next meeting, things like that. We're modifying our communications policy template to include language now that this bill is going to be signed into law, or most likely will be, to include language that allows the board to limit the number of inquiries per 30-day period to take advantage of that option under the statute. So the bill requires a substantive response within the 30-day time frame. Substantive response is actually defined in the statute and allows boards to limit the number of responses that they have to provide, and allows the board to ask for an extension of 30 days or to notify the owner that it's going to take an additional 30-day period of time when they have to deal with a complicated question or request advice from a professional in responding. All of this is really different than a records request. A records request is just, I want to see all of the fill in the blank records for the last 2 years, right? I want to come review all of the board meeting minutes that the association has on record since forever. Or I want to review the financials for the last 18 months. Or I want to review all of the association records. I have one client that's actually in litigation with a homeowner right now dealing with a very, very, very expansive request to review basically all association records for a very long period of time. The statute requires that you respond to that and make the records available for inspection in the manner in which those records are kept in the ordinary course of business. You can charge the owner a reasonable fee to facilitate that records request. You can also charge them for copies of records if they request those records. You are obligated to redact certain things from those records if there's privileged or private information that shouldn't be disclosed. That's a whole different process than, I'm sending you this letter. I have this list of 5 questions about the way the association is doing business, and you have to answer my questions substantively. That's the difference, right? So the reason for this, like I said at the beginning, is that there is a perception that it's a widespread problem. I have no doubt that there are occasionally boards that just refuse to respond to owner requests, and whether there's a reasonable basis for them doing that or not is a whole different discussion that we don't have to have here, right? But I think it is by far the exception to the rule. The vast majority of boards are doing the best they can, are trying to communicate in good faith with their owners when questions are asked, et cetera. But that's not the perception in Olympia, and that's where this bill came from. So keep in mind, it's only relevant when you receive a certified letter asking for these questions to be answered. And if and when you receive one of these letters from a homeowner within your community and you're confused about how much time you have to respond or what you should say or whatever, reach out to your association attorney and ask for a little bit of guidance. All of what has happened in Olympia lately regarding a community association governance has been with an eye towards transparency and disclosure to the ownership. So if you're confused about something, err on the side of disclosure, except for those things that are very clearly outlined in the record statutes that are meant to be private and not disclosed to the ownership. So Jen, did you have anything you wanted to add to that?
No, I think you covered it.
Okay, before you jump to the next question, I do want to very briefly touch on 2 other bills that passed, just that are, kind of an FYI for people. One is Senate Bill 6054, and that is a bill that requires associations to allow unit owners or property owners to use fire hardened materials as long as those materials meet building code. And one of the changes that we advocated for and were able to get into this bill was that associations are allowed to regulate the appearance of the building materials in a reasonable way. Originally, the bill had a cap on basically the associations could only regulate appearance and the use of these fire hardened building materials to the extent that it would only add no more than 10% cost to the owner's process, whatever it is that they're, like, let's say they're putting siding on their house or they're replacing their roof. An association would have been limited to appearance related rules that they were only allowed to make rules that would add 10% of cost to the owner's outlay for whatever that item is. And we were able to get that removed and allow associations to adopt reasonable rules about appearance. But an association is not allowed to ban the use of fire hardened materials. And this is all just about making homes more resistant to fire, right? So that's Senate Bill 6054. Where that is going to have the largest impact is going to be mostly in single family home HOAs that have aesthetic requirements and limitations when it comes to building materials that can be used on the exterior of the single family homes within those communities. And the other bill that was passed is House Bill 1500, which is about resale certificates. And this one was one that we negotiated long and hard. And um, it changes the resale certificate section of WCIWA, which is RCW 6490-640. Associations have to include in the resale certificate all policies and procedures. They have to provide the full reserve study, not just a summary. The $275 charge that has already been in the statute for a while has to be for direct costs of copying and providing information. So you can't add, like, basically it caps the cost to the unit owner at 275, except for, I think there is an exception for a rush fee when it's asked, when the resale certificate is requested in less than a certain amount of time. But you can't add document fees and title fees and all kinds of other fees to essentially inflate the cost of a resale certificate. Um, Associations cannot require that owners contract or establish an account with a third party to provide payment for or accept delivery of the resale certificate. And what this does is it at least raises a question about the use of third party resale certificates like HomeWise and such, condo certs, because does it count that an owner might have to create an online login and password to request a resale certificate from one of those third-party vendors? Does that count and sort of violate the text of this bill? We tried to get that language clarified or removed, and the sponsor of the bill was unwilling to do it because the realtors lobby, for whatever reason, was adamantly against it. There's a perception from the realtor side of things that using third parties like Condo Certs and HomeWise makes resale certificates take longer. And what I'm hearing from all of my management contacts, like overwhelmingly, is that the opposite is true. So it'll remain to be seen how this particular language in the statute affects the resale certificate process going forward. Another thing that's really pivotal in this bill is that new owners are not responsible for any violations of the governing documents for alterations to units that were not revealed on the resale certificate if the violation should have been apparent to the association exercising reasonable diligence. So what this means is if there is a like a architectural violation or structural violation or whatever that the association should have known about if it had exercised reasonable diligence, and that violation is not disclosed on the resale certificate, then the buyer cannot be held liable for it. We worked really hard to get that reasonable diligence language in there because the way it was written originally would absolutely have, and I know that somebody would have made this argument because people like to argue in court and sue over ridiculous stuff, would have been interpreted or could have been interpreted in a way to require condo associations to inspect the interior of a unit to ensure there were no interior violations in order for this to comply with and to make a buyer liable for correcting those violations. So we worked really hard to get modified language. That's where the reasonable diligence thing came in. So an association is not going to be held up over an interior violation that it could not have known about, because most of our condo clients don't have access to the interior of their owners' units. So all of that being said, that is House Bill 1500, sorry, Senate Bill 1500, and is the other one that we just wanted to at least briefly, or maybe not so briefly, I don't know, recap for you all, because those are currently sitting on the governor's desk awaiting signature. I actually didn't check today to see if any of them have actually been signed, but the governor has 90 days to sign them. Otherwise, they automatically become law and will take effect. I believe it's mid-June. I'd have to look up the date to see if I'm correct on that. So I'll correct myself next week if that's the wrong date. So now I'm done. Sorry, Jen.
No worries. So our next question, I read where if an HOA is governed by 6438 and the roofs of the units are maintained and or replaced as a common asset, that the association is not required to allow solar panels. Is that still correct, or has the law changed? Excuse me. Should we expect that to change in 2028? So that understanding is not correct. 6490, excuse me, for 6438 communities, the statute is 6438055. 6490 communities, and after 2020, January 1st, 2028, it's 6490510 subsection 3. So 6490 is more detailed and more protective of the association. It spells out exactly what standards solar panels must meet and limits the association's ability to impose restrictions beyond safety and certification requirements. This is especially important for condominiums because roof rights and common elements complicate solar installations. So, as an HOA, you still have the ability to put some reasonable restrictions on solar panels where they can be located and ensuring that they're installed properly. If the roof is paid for, the maintenance, repair, replacement paid for as a common expense, you still are required to allow solar panels. And I believe that's been the case since, I want to say, about 3, 4 years ago, but I could be mistaken on that. If you scroll to the end of the language of a statute, it will have when the language was last updated. So that will tell you when that language was done. Valerie, do you have anything to add to that?
I don't. So I'm going to jump us to the next question. We have an owner who has stated that all board members can be sued individually at their own personal cost and directly to one board member twice and in an email. This same owner attends monthly meetings, harassing and bullying and threatening board members, plus defamation of character of board members to other neighbors. What language can the board put on a meeting agenda and minutes addressing this? So I want to start by saying that when you are the subject of harassing and bullying and negative sort of information campaigns like this, it is incredibly frustrating. It is very easy to, it's very emotional. It's very easy to want to react and respond to every allegation that someone makes. And what I would like to start us with is a thing that my mom always used to say. I think I quote my mom a lot in this Q&A. And that is that you do not have to accept every invitation to an argument that is issued to you. So I guess I'd like us just to start there and say, and just acknowledge that just because someone else wants to argue with you, or me, does not mean that we have to argue back. We are not required to respond to every argument that someone tries to start with us. So let's take a step back and talk about some of the content in this question. First of all, the statutes generally say that when an owner is challenging an association action, their lawsuit and their beef is with the association, not with individual board members. Individual board members are generally protected from personal liability for decisions made acting in their capacity as board members, as long as they are meeting their duty of care. So unless as a board member, you are ignoring your duty of care, making self-interested decisions, taking matters into your own hands that you shouldn't be doing, unless you're a rogue board member, as sometimes they're referred to, then your actual liability as an individual in most cases is extremely limited. On the other hand, let's acknowledge that anybody can sue anybody for anything as long as they're willing to pay the $250 filing fee to file a lawsuit with the county. They can sue anybody, but the question is whether you have any actual liability in that lawsuit. And the answer to that question is almost always no, or very little. And on top of that, most associations have insurance that will appoint defense counsel to get claims against individual board members dismissed when they are named improperly for actions taken when acting in concert with the board as a whole and meeting the duty of care. Most declarations also have indemnification provisions that protect board members from individual liability for actions taken as a board member, as long as, again, they don't violate their duty of care. And D&O insurance applies or may also apply depending on the types of claims that are being made. I think in general, the less you respond to someone who is making accusations at board meetings or on social media or whatever, the better. I think the more you respond, the more credence it gives to their commentary. Um, and and the way that I'll give you an example of this is that those of us that use social media, whether it's Facebook or Instagram or any other form of social media, when you post something on Facebook, a certain subset of people will see it in their feed, right? But then every time somebody else comments on that thing, it makes it more and more visible to more people within your friends list or your group of followers, right? So if you get no comments, the smallest number of people possible will see that thing. And the more comments that you get, and the more you respond to other people's comments, and the more that then people respond back to you, the more visible it becomes to everybody, the more it sort of hangs around as a current conversation on social media. Um, so one of the things that I would suggest is that you just deprive these types of claims of oxygen and credibility by mostly ignoring them when it's possible to do it. Now, if an owner shows up at a board meeting and is being inappropriate and disruptive, you can remove them from the meeting after warning them and telling them that if they do not stop disrupting the meeting, they will be removed. That is a statutory right that community associations have. You can look at 6490-455, subsection 2A, which allows you to remove a disruptive person from a meeting after they refuse to settle down, after they've been warned and refuse to settle down. You should not prevent that owner from commenting however they want to comment during the owner comment period at the beginning of the board meeting. Now, if somebody is like threatening or using profanity or something, I think there might be some argument that could be made otherwise, right? But simply because you know they're problematic and they're going to say bad things about the board doesn't mean you should not allow them their 90 seconds or whatever the time frame is during the owner comment forum at the beginning of the board meeting. Remember that the owner comment period is not a time during which owners get to interrogate board members and require a response. It is simply a time for the owners to address the board, and your role as a board is to just listen, thank them for their comments, and then move on to the board meeting without any further interaction required unless the board wants to interact further or ask for clarification on something. Other things that you can consider doing are adopting a communications policy, which I mentioned earlier in the context of talking about, responses to written inquiries from homeowners. But communications policies can often, and ours do, also contain anti-harassment provisions in them, anti-discrimination provisions in them. They also set expectations for your owners for how often they're going to hear back. So, again, I said earlier today, we all are familiar with that owner who, they're going to send 14 emails a day until you respond to them. And you do not have to respond to those 14 emails. You can have a communications policy that says, unless the email pertains to an emergency related to the property, all emails will be reviewed on a weekly basis and topics will be added to the board meeting agenda as appropriate, and issues will be discussed at the next board meeting on the regular schedule. Written responses, if any is required, will come following the board meeting or following the board's opportunity to make a decision. So what that does is it sets expectations and it gives you the ability to have boundaries when it comes to how often you respond to owner communications like this. Lastly, I would like to share some commentary that actually Ken wrote for us when he looked at this question. So I'm going to read it, but Ken is the one who wrote it. So I'm going to read it in the first person, but this is Ken's commentary for you all, because I think it's just so incredibly helpful. This is what Ken said. I share your frustration over the ability of owners to post anything they want to social media websites. As a victim multiple times of false and misleading posts and negative reviews and comments being posted on the internet, I would offer that my best advice is to ignore it. The second best option is to respond with very short, factual statements, one time only, suggesting that readers research and get objective opinions rather than trust an individual who may have an axe to grind. I usually only respond to something posted with the Better Business Bureau or some other high profile or legitimate website. I have been in interviews with clients and have had them pull up negative comments from owners or board members, like, fill in the blank. And uniformly, they have been understanding when I explain that the person involved had a difference of opinion with me or with the board. And so they were trying to get their way by posting negative comments on social media. Because you are the target of these comments, you have a strong reaction to them, as I have in the past. But to most of the world, those postings will never be read. Those words or commentary will not be considered, especially when weighed against the positive comments or referrals that you might get and how you come across in person. The more a person like this talks and posts, the less effective their efforts usually are. The legal alternatives are so time consuming, expensive, and ultimately ineffective that trying to ignore it and just going about doing your good work is the most effective thing to do. I wish there was more that I could offer or that I could advise that the association has some power to silence an owner like this, but I cannot. So that was Ken's commentary, and I will add mine to that. I think probably every lawyer in our firm has had somebody say something nasty in a Google review or file a bar complaint because they didn't like the way that we were advocating for a client. Or I was in an association meeting a while back, helping conduct an election, and an owner just called me a liar right on the Zoom in front of everybody else in the meeting. And the more you give credence to that kind of commentary and the more you sort of allow yourself to react emotionally, it just adds fuel to the fire. And the goal, I think, is to deprive that fire of oxygen. And part of how you do that is to ignore it whenever possible and only respond when absolutely necessary. Um, so I think that's it on that question, unless Jennifer, you want to add anything else.
Honestly, we've had clients get sued by these problematic owners. One particular client had an owner file, what was it, 4 or 5 small claims cases.
Oh my gosh.
You know what I'm talking
Yeah.
about.
Yeah. Yeah.
So the vast majority of associations have at least one individual like this who's just a complete and utter pain in the rear. But how much of a following do they actually have? And reminding people that just because someone is the loudest in the room, jumping up and down and screaming and making all of these wild accusations, as long as you are factual and reply as required with the facts, the more people will listen to you and not the idiot screaming in the corner.
Well, that brings us to the end of our prepared questions. There's one question so far that's been posted in the chat. So if anybody has any other questions that you want to pop in there really quickly right now, we'll try to get to it once we're done answering this question. I think this is going to end up being a very short answer. So the question is, if a board wants to make a resolution to have emergency approval on specific items, how high can the approval dollar amount be before getting into trouble? 2,000, 5,000, 10,000? I'm gonna just briefly comment on this and then let Jen jump in, because this is definitely something she's got a lot more experience with than I do. And I think the answer to this question is probably too specific, and not just too specific. It really depends. Are you a 10-unit condominium or are you a 3,000 home HOA? It depends on the type of community. It depends on what your governing documents say. It depends on how you're defining an emergency. And it probably depends too, at least somewhat, on what the contents of the management contract say with each community that you manage. So I would say that's less relevant from our perspective, which is advising associations and not management companies. Um, I don't think that this is something we can answer in the context of the Q&A with a hard and fast, this number is always going to be fine and this number will always get you in trouble because of the variations that I just mentioned. But I would love to hear Jennifer's perspective if she has anything additional to add here.
Valerie's right. There are too many variables for us to answer this question, and it really depends on the particular situation. The Under the current meeting statute, 6490-455, this came into effect January 1st. The board can only make decisions at open board meetings. By resolution of the board can authorize two board members, one board member, the management company, however you want to do that, to answer to particular situations that come up in between board meetings. So, say someone has a leak and they need to get the mitigation people in, they need to start getting bids. How that works is dependent on number one, the language in the resolution, and number two, what kind of authority are you willing to give? So, authorizing someone, say in the realm of a leak or damage to the building or what have you, to initial response, get the problem stopped, start the bidding process, and then have everything ratified at a board meeting will likely be okay. This is a very new statute. There is no case law on this yet, interpreting what the legislative intent was or what anything means. So as long as you are reasonable, and honestly, as boards and managers, ask the attorney. Run the resolution by the attorney to make sure that you're on the right track and there's less risk. You're also shifting risk so that if the attorney makes a mistake, the liability comes to the attorney, not to the management company or the board.
Agreed. All right, we have a couple amendment related questions in the chat. And I think if you're okay with it, Jen, I'll do the same thing, which is that I'll take my stab at it and you can add your depth of information on top of it. One is, can we collect signatures for amendments by DocuSign? And the answer to that question is yes, but you don't have to collect signatures. You have to collect votes. So you can collect votes electronically as well as on paper with a wet signature. And the related question is, if the unit changes ownership during the course of the election, I'm assuming this means during the course of voting for an amendment, can we still count prior owner votes if they were the owner when they voted? And the answer to that question is no. If you're holding voting open for a restatement or an amendment or whatever for, say, 5 months or something, and during that time somebody votes yes for the amendment and then sells their unit, and the voting continues because you don't have the percentage that you need yet, you need to send a ballot and get a vote from the new owner, and you cannot count the vote from the no longer owner in your final tally of voting when you get to the point that you think you're close on the percentages. Jen, did you have anything additional to add on those?
Just briefly, if you send out paper ballots or have some sort of absentee ballot for a amendment, DocuSign works. However, you can get votes back works. As long as you're able to trace that vote back to the individual owner. If it's a vote by a secret ballot, then you need to be able to trace that a particular owner has voted, but you can't keep the ballot or have to somehow divorce the owner from their particular ballot. But it really, however you can get votes back works. But Valerie is completely correct. If a unit changes ownership during any sort of vote, the new owner's vote is the one that counts, not the prior.
Thanks, Jen. I think that takes us to the end of what we've got today. There are no additional questions in the chat, and we're just about 5 minutes shy of 11, so we're going to call it a day. Thank you all for joining us. We will be back here next week, but keep in mind we will not be having a Q&A the following week. So we will see you guys back here next week. Thanks, everybody.